Clarence Thomas entered the hearing projecting the weight of decades on the Supreme Court. Within minutes, Jasmine Crockett had him cornered with questions so precise, rooted in his own rulings that any answer risked contradiction. The moment his face appeared on the committee screen, the air tightened. This wasn't a room of casual spectators. It was packed with lawmakers, legal aides, journalists, and citizens eager to witness one of the most consequential hearings in years. At the far end of the panel, Crockett sat in a charcoal blazer, eyes locked on Thomas, not scanning notes, not flinching. When recognized by the chair, she skipped pleasantries. "Justice Thomas, let's talk about undisclosed travel and gifts from individuals with potential business before the court." Thomas leaned forward, hands clasped. "I've served this country for over 3 decades with honor. I trust you understand the judiciary's independence." It wasn't an answer, it was a framing move, casting himself as the seasoned veteran. Against a newer legislator, Crockett didn't blink. "I'm also aware that public trust depends on transparency. So I'll ask again, have you accepted travel accommodations or gifts from parties with business before the court in the last 5 years?" A shift rippled through the room. Thomas let silence hang before deflecting, asking her to rephrase. Crockett refused to be thrown off. Then came her strike. She directed him to page 37 of the committee packet. Records of a 2022 private flight to Jackson Hole, paid for by a donor whose company filed an amicus brief before the court, months later never disclosed. Thomas's eyes dropped. "I'll need to review the specifics before commenting." Crockett slid the evidence toward the clerk. "Then let the record note you cannot explain this today." The gallery murmured. This wasn't grandstanding, it was precision work, methodical and undeniable. When Thomas tried to caution her about implying misconduct, she cut in calmly. "I'm not implying anything. I'm stating documented facts and asking for clarity." It felt like a courtroom duel compressed into minutes. And it was only round 1. Outside, reporters filled the Rayburn building corridors. For months, America had debated judicial ethics. Now, it had dates, names, and dollar amounts and a Supreme Court justice facing them in real time. Commentators called the hearing a stress test for accountability at the highest level of the judiciary. At its center was Jasmine Crockett, a congresswoman from Dallas, Texas, known for meticulous legal preparation and an unshakable refusal to be intimidated. In the weeks leading up to the session, Crockett's office became a hive of focused activity. She wasn't there to grandstand. She wanted precision. Her legal team pulled records from the Senate Judiciary Archives, combed through years of disclosure forms, and reviewed archived interviews in which Clarence Thomas had spoken about judicial ethics. Her guiding principle was simple: no vague accusations, no speculative traps, only facts that could stand on their own. That morning, Washington felt charged in a way it only does when something historic is about to unfold. Constitution Avenue was lined with cars. People paused at food trucks, earbuds in, listening to the live feed from the Capitol. The buzz wasn't just political, it was about whether a sitting Supreme Court justice would finally face questions that left no room to sidestep. When Crockett walked into the committee room, she carried only a slim binder and a coffee. She didn't need the binder for every fact. It was more a pacing tool. Her staff had drilled her in mock sessions for hours, playing the part of a hostile witness ready to interrupt, challenge, and deflect. That preparation mattered. Clarence Thomas wasn't just any witness. He had survived decades of political storms and emerged largely unscathed. His defenders saw him as a steadfast originalist, his critics as a justice compromised by personal and financial ties. Both sides knew the day could tilt the narrative. For the committee, the stakes were broader than Thomas alone. If a justice could accept undisclosed benefits from those with interests before the court without consequence, what did that mean for the separation of powers? For the public, the question was even starker: could the highest court still be trusted to play fair? At 10 a.m., the gavel came down. Early witnesses spoke cautiously, offering neutral commentary on ethics and public perception. But everyone knew the main event was Thomas's testimony, and especially his exchange with Crockett. The media had framed it as a clash between two sharply different legal minds, one steeped in decades of judicial tradition, the other rising quickly in Congress with a reform-minded edge as members took their turns. Crockett listened intently, studying Thomas's rhythms when he answered quickly, when he hesitated, when he tried to redirect. By the time her name was called, the audience leaned forward, anticipating something different. Where others allowed Thomas to drift into long speeches, Crockett was known for keeping witnesses tethered to the question. In her earlier exchanges, Thomas projected authority while she refused to yield. Now, momentum was building, and both knew it. When the chair yielded the floor, Thomas adjusted his glasses and leaned into the microphone. "Congresswoman," he began, "I've noticed your line of questioning seems less about facts and more about framing me in a particular light. I must say, I take issue with that. It was a calculated move-on attempt to put her on the defensive, to suggest political bias." Many questioners would have faltered. Crockett didn't even shift in her seat. "With respect, Justice," she replied evenly, "my questions are grounded in documented records, many of which were submitted by your own counsel. If the facts are uncomfortable, that doesn't make them any less factual." A ripple passed through the room. Some members hid faint smiles. Others stiffened. The tension was rising. Thomas clasped his hands, leaning forward. "I've given decades too, and the next exchange promised to push the room to its breaking point." "I've spent decades interpreting and defending the Constitution," Thomas said. "I would think my position has earned me the benefit of the doubt." Crockett leaned forward. "The American people give the court their trust, Justice. That trust isn't permanent, it's renewed through transparency. And today, transparency is what we're here to secure." Her tone never rose, but the words hit like a gavel. Pens scratched faster in the press row. Thomas's face tightened. "I must remind you, Congresswoman, that the separation of powers exists for a reason. The legislative branch does not dictate how the judicial branch conducts its affairs." "Must remind you, Justice," Crockett replied without pause, "that the Code of Conduct for United States, judges which your court has now voluntarily adopted, states clearly, a judge must avoid impropriety and the appearance of impropriety. In all activities, this isn't about dictating. It's about accountability." The room went still but for the low hum of the ventilation system. Thomas opened his mouth, then closed it again. "I believe I've adhered to that code to the best of my ability." "That's not the standard," Crockett said. "The standard is whether a reasonable person, knowing the facts, would question your impartiality. And in several documented instances, Justice, a reasonable person might." The balance of attention shifted toward her. Members leaned forward. "You speak as though you understand the pressures of this role," Thomas said slowly. "But you've never sat on this bench." "True," Crockett answered, calm as ever. "But I've sat across from witnesses who tried to talk around answers. I've read enough rulings to know your words carry weight far beyond this room. That's why it matters how you act when no one is watching." Thomas adjusted his approach. "You've asked about my travel and hospitality records. Some omissions are clerical honest mistakes. I'd hope you recognize the difference between error and misconduct." "I do," she said. "But when the same omissions appear repeatedly over years, always involving benefits from people with cases before the court's reasonable minds might question whether they're accidents." Her words hung in the air just long enough to bite. "I believe this committee has more pressing matters," Thomas began. "This committee decides what's pressing," Crockett cut in smoothly. And today, that includes your pattern of omissions. Down the dais, a senior member murmured to a colleague as cameras zoomed in on the split screen of Thomas and Crockett. The moment had become more than a hearing, it was a duel. Then Crockett shifted, adjusting her microphone with deliberate calm. "Justice Thomas," she began, "I'd like to submit Exhibit D into the record." The clerk distributed the documenta. Signed acknowledgement form required when federal judges accept certain gifts or travel benefits. The date was clear: September 15th, 2021. This document shows you acknowledged receiving a private charter flight to Bozeman, Montana, Crockett said, paid for by an individual with active litigation before the court. This acknowledgement was not disclosed on your annual financial report, filed months later. Can you explain the omission? Thomas glanced at the page, then back at her. As I've said, there are clerical issues in any large institution. Forms pass through staff, and this wasn't filled out by staff. Crockett cut in. It has your signature, filed directly with the administrative office of the U.S. courts, certified by you. He hesitated, not long, but long enough. For the cameras? If I failed to follow through on the report, it wasn't intentional. I sometimes rely on staff to track obligations. Crockett leaned in, her voice still level. Justice Thomas, in your own concurrence in United States v. Loughran, you stressed that when the law sets out a procedure, it must be followed exactly, not optional, essential, as you wrote. Crockett leaned in slightly. So why is your adherence optional here? A murmur moved through the gallery. It was rare to see someone turn a justice's own legal reasoning back on them in real time. Thomas adjusted his tie. My opinion in that case applied to statutory requirements in criminal law, not administrative oversight. Did the principle doesn't disappear when the context changes, Crockett replied, steady and unshaken. Public trust in this court depends on you following the rules the same way you expect others to. Thomas rested his hands on the desk. I assure you, nothing I've done has compromised my impartiality on the bench. Crockett tapped the folder in front of her. The appearance of impartiality is just as critical as impartiality itself. That's not my opinion, it's from the code of conduct you're now bound by. From the press row, a reporter whispered to a colleague, already imagining the headline. Thomas tried to pivot. This assumes that friendships and social interactions automatically translate into influence. That's not how it works. And yet, Crockett countered, the public doesn't get to audit your friendships. They see the benefits you've accepted and the cases that follow, and they draw conclusions. That's why the rules exist, to remove the need for speculation. Her voice was calm, without sarcasm or frustration. The silence that followed wasn't from a lack of words, was the pause of someone realizing the ground had shifted beneath them. I'll move to my next question, she said finally. But let the record reflect this omission matches at least 4 other incidents in the past 7 years. The chair nodded, instructing the clerk to enter it into the record. A Georgetown law professor in the back row scribbled furiously. Without accusing Thomas of bad faith, Crockett had established a pattern. The facts were now public. Thomas shifted. Again, his earlier control dimming. Then Crockett opened her binder to a yellow tabbed section. Justice Thomas, are you familiar with State of Missouri v. Franklin Industries 1998? A faint crease formed on his brow. I recall it generally. Industrial zoning dispute. That's right. In your concurring opinion, you wrote, judicial. Integrity demands that a judge avoid impropriety and the reasonable perception of impropriety, particularly where personal relationships intersect with professional duties. Is that accurate? He pressed his lips together. That is the general sentiment, yes. Good, Crockett said. Because the donor who funded the Montana trip we just discussed is the same individual who organized a 2019 private conference attended by multiple parties with active litigation before the court cases you later ruled on in their favor. 6-3. Thomas leaned back. I've attended many conferences, some public, some private. It's not unusual for the judiciary to engage in academic discourse. This wasn't an academic symposium, Crockett said, her tone sharpening. It was an invitation only. Retreat at a luxury lodge in Big Sky, Montana, with an agenda from an advocacy group whose cases you heard and sided with. The room's energy tightened. Several committee members exchanged quick glances, and those in the gallery leaned in, sensing the balance of the exchange was shifting. Thomas spoke slowly. You're making an implication I find inappropriate, Congresswoman. I'm not making an implication, Crockett replied evenly. I'm connecting publicly documented events to your own stated standards for judicial integrity. By your definition, wouldn't this create a reasonable perception of impropriety? For the first time, Thomas hesitated. The pause was brief, but unmistakable. Perception is subjective, he finally said. What one person deems improper, another might see as a normal professional interaction. That, Crockett answered, locking eyes with him, is precisely why disclosure. Rules exist, so personal opinion doesn't dictate whether the public can trust a judge's impartiality. His jaw tightened. I have always acted according to my conscience and my understanding of the law. Then perhaps your understanding, she said, without missing a beat, needs to align more closely with the public's right to know. Because right now, millions of Americans are watching and wondering if the scales are balanced the same for them as for the most powerful jurists in the country. Thomas said nothing, but the cameras caught his brief glance downward before returning his gaze. From the press row, an NPR journalist whispered, "She's tightening the vise." As fingers flew over keyboards, Thomas shifted to a softer tone. Congresswoman, you've built a career advocating for fairness and equality. Surely you understand reputations can be harmed by incomplete narratives. I understand, Crockett countered, that reputations are protected by full transparency. And when the facts are complete, the narrative speaks for itself. The committee chair cleared his throat, mindful of the time, but unwilling to cut her off. This isn't about attacking your career, Crockett continued, closing the binder in front of her. It's about protecting the integrity of a system that depends on trust from every citizen, regardless of wealth or influence. Thomas gave a guarded nod. I have a few more questions, she said, glancing at the clock. In your 2011 Senate Judiciary testimony, you called disclosure requirements the public safeguard against corruption. How do you reconcile that with repeated failures to disclose gifts and travel from individuals with interests before the court? Someone in the gallery drew a sharp breath. Thomas straightened. I stand by that statement. I believe the safeguard works when applied in good faith. And yet, Crockett said quietly, good faith without transparency is just a request for blind trust. That's not how the law works. Her words landed without the need for emphasis. But she wasn't finished. Reaching into her blazer, Crockett withdrew a single folded sheet of paper, no binder, no tabs. She unfolded it with deliberate care and placed it before her. Justice Thomas, she began, her tone calm but weighted. Are you familiar with Harrington v. United States? Decided in 1983 by the Eighth Circuit. Thomas frowned slightly. That was before my time on the court. I know of the case, but haven't reviewed it recently. I'm not surprised, Crockett replied. It's rarely cited except in one concurrence you wrote in 1996, in Reed v. Missouri Board of Ethics. You relied on Harrington in your reasoning about judicial recusal and the appearance of bias. Thomas's brow furrowed further. She had reached back decades to connect an obscure appellate ruling to his own judicial philosophy. In Reed, she continued, you wrote that a judge must recuse not only when actual bias exists, but also when his conduct creates a reasonable perception of bias in the eyes of a well-informed observer. Is that accurate? That appears to be accurate, Yes, Thomas said. Good, Crockett replied, leaning in slightly. Because Exhibit F, now before the committee, details your attendance at a closed-door dinner in 2020 hosted by Do. You want me to continue this so it builds to the confrontation's breaking point. The Center for Constitutional Influence, funded almost entirely by a corporate interest with a pending case before the court that same term, had hosted a private dinner. Thomas attended but did not disclose it. The case was later decided in that corporate interests' favor. Papers detailing this landed on the desks of each committee member, the shuffle of pages filling the air. On page 2, a high-resolution photograph showed Thomas seated under a chandelier at a long table, speaking with the organization's founder. The date stamp was unmistakable. Thomas cleared his throat. Congresswoman, I attend events as part of my duties to engage with the legal community. That does not mean my decisions are influenced by those present. Crockett nodded slightly. Understood. But according to your own standard from Reed, the question isn't whether you were actually influenced, Dix, whether a well-informed observer would perceive bias. Wouldn't a reasonable observer, seeing you at a private dinner with a stakeholder in a pending case, question your impartiality? He paused, weighing his words. I think reasonable observers would also take into account my decades of service and consistent jurisprudence. That's not the legal test you set in Reed, she replied evenly. The test is whether the appearance of bias exists, period. By that standard, this dinner meets the criteria for recusal. The energy in the room shifted. No one interrupted. This was no longer about omissions. Was about contradicting his own published judicial philosophy. Thomas's voice grew firmer. Congresswoman, hindsight lets us see events differently. At the time, I did not believe attendance required disclosure or recusal. Crockett tilted her head. And if another judge, perhaps one you were reviewing, took the same action under the same circumstances, would you accept that justification? Silence. Cameras clicked. A reporter whispered, he can't answer without cornering himself. Finally, Thomas said, I would evaluate each situation based on the full context. Justice, Crockett replied. Context matters, so does consistency. When your own words from the bench set a higher standard than the one you follow, the public's faith erodes. That's not conjecture. That's history. She didn't gloat. She let the statement sit. The chair glanced at the clock, but didn't cut her off. Thomas adjusted his glasses, clasping his hands. I stand by my record, he said, and the record now includes this exchange. She answered, so the American people can judge for themselves. The balance in the room had shifted. It was now defending himself against his own precedent. And Crockett wasn't finished. Her next question would push him into territory where hesitation would be damning. The air seemed heavier. Thomas, once leaning forward with confidence, now sat back, one hand on the desk, the other adjusting his glasses more often. Crockett let the silence work for her. At last, she spoke. Justice Thomas, do you recall testifying before the House Judiciary Committee in 2011 about the importance of avoiding even the appearance of impropriety? I do. And do you recall saying that transparency was not just about meeting the letter of the law, but about preserving the spirit of public trust? I believe I said something to that effect. Crockett picked up a paper. Not a belief, just a seats in the transcript. You told this body, and I quote, if the public cannot see that the judiciary holds itself to the highest ethical standards, then it cannot serve its role as a co-equal branch. She set the paper down. Were those your words? Thomas's gaze flicked to the monitor in front of him before settling back on her. Yes, those were my words. Then help me understand, Crockett said evenly, how that principle applies when you accept undisclosed benefits from people. With business before the court, he drew in a breath. "Congresswoman, I reject the premise that my impartiality has ever been compromised." "I'm not talking about your impartiality," she replied, without missing a beat. "I'm talking about the perception of it. That's your standard. Justice is not mine." The pause that followed was long enough for the faint click of camera shutters to be heard from the press gallery. Perceptions, Thomas began carefully, can be shaped by misleading narratives. Much of what's been reported about my personal associations has been framed unfairly. And whose responsibility is it to make sure the record is clear? She asked. The press, your critics, or you? His mouth opened as if to answer, then closed again. The hesitation was brief, but in a hearing like this, brief was enough. This committee, Crockett continued, isn't here to tell you who you can or can't associate with. We're here to determine if you've met the obligations you agreed to uphold. So far, your explanations don't match the standards you've set for others. Thomas shifted in his seat. I believe you're reading my past statements out of their intended context. I'm reading them exactly as they were written, she said. And context doesn't erase the principle they stand for. She reached for another Documenta Congressional Research Service report. This shows your disclosure record over the last decade. You have more amendments and late filings than any other sitting justice. Can you explain why? Thomas blinked. I wasn't aware of that statistic. That's why I'm giving it to you now, Crockett said. The public deserves a justice system that's proactive in meeting its obligations. It's not one that waits for investigative journalists to dig things up. For the first time that day, Thomas looked down and stayed there. His hand smoothed the edge of a paper stack that didn't need straightening. No one here doubts your influence on American law, she said. But the same law you've shaped requires you to hold yourself to a higher standard, not because it's easy, but because the role demands it. The chair glanced at the clock. Crockett lifted a hand slightly. I'll close with this. The court's legitimacy isn't measured by how fiercely its members defend themselves. It's measured by how willingly they hold themselves accountable. She placed her pen down and locked eyes with him. Thomas gave a small nod, whether in agreement or simple acknowledgement, no one could tell. But before the moment could settle, Crockett delivered the strike that would echo beyond the chamber by the time the hearing adjourned. Clips of her exchanges were everywhere. Instagram, YouTube, one 20-second cut, showing her quoting his own Reed v. Missouri Board of Ethics concurrence and asking if he'd hold another judge to the same standard. Spread like wildfire. By 4 p.m., Crockett versus Thomas was trending nationwide. On MSNBC, Law. Professors called her questioning methodical, precise, and devastatingly effective. On CNN, a former prosecutor noted, she never raised her voice, and still put him on the defensive like I haven't seen in years. Even Fox News hosts admitted begrudgingly that she'd been prepared and unflappable in Dallas. Her home district radio callers praised her command of the facts. She's not afraid of anyone, one said. No matter their title. Memes popped up instantly. Split screens of Thomas looking down beside Crockett, staring straight at the camera. TikToks with captions like, when your receipts go back 30 years. And by the next morning. Editorial boards from across the spectrum were weighing in not just on the exchange, but on the standard she'd forced him to confront, his own. The Boston Globe praised her for raising the bar for congressional oversight. The Wall Street Journal, while critical of what it called theatrical elements, still conceded that her questioning exposed glaring gaps in the justices. Disclosure record gaps that couldn't be ignored. Inside the legal community, the exchange was already a case study. Law professors were pulling up the footage in ethics classes, asking students to dissect both the questions and the evasions. Her calm delivery, airtight documentation, and strategic use of precedent turned the moment into a textbook example of cross-examination outside a courtroom. But Crockett's day didn't end when the cameras shut off. Back in her D.C. office, staff told her the phones hadn't stopped ringing calls from constituents, advocacy groups, even retired judges. One former appellate judge left a voicemail with just 9 words. "You reminded the country that Congress still has teeth." Thomas's team scrambled to control the damage. Within hours, a carefully worded statement appeared on his official page, insisting the omissions were unintentional and the gifts personal in nature, denying any influence on judicial decisions. But the viral clips weren't about influence. They were about whether he'd lived by his own rules. By Friday, polling from a nonpartisan watchdog group showed a noticeable jump in public support for stronger judicial ethics laws. Most respondents cited recent events as the reason. Crockett played down the attention. Speaking to Texas Public Radio, she said, "It's not about going viral. It's about doing my job. The law is supposed to apply equally to everyone. If I can't ask those questions, I shouldn't be here." Still, she couldn't ignore what had shifted. For years, hearings involving the Supreme Court were sleepy, procedural affairs. This one cracked the door open, showing how power could be challenged when preparation met timing. Attorneys from Los Angeles to Miami were emailing each other the clip under subject lines like "This is how it's done." They weren't applauding political theater, they respected the technique. She hadn't browbeaten him, hadn't raised her voice. She'd simply laid out the facts and asked the one question he couldn't answer without contradicting himself. In a political climate where hearings often collapsed into partisan shouting matches, Crockett had proven that precision could cut deeper than volume. But away from the lights, she was already thinking ahead. The next moves would decide whether this was just a viral moment or the start of something that could reshape accountability at the highest level. When the committee adjourned and the gavel's final strike faded, reporters called out last questions. Aides boxed up papers. Camera crews dismantled their rigs. Crockett stayed seated until the room thinned, then rose. Her senior aide, Tasha Reynolds, leaned in. "You're going to be on every cable show tonight." They're calling it the Reed precedent moment. Crockett gave the faintest smile. "It's not about moments, Tasha. It's about the record. If it's not in the record, it's just noise." They walked into the marble-lined hallway, now cool and quiet, only a few lingering staffers offering nods of respect. In her office, she slipped off her blazer and draped it over her chair, the day's adrenaline giving way to the familiar post-battle weight, her policy director. Luis Moreno had been watching from the overflow room. "You were surgical in there," he said, handing her a printout of the media coverage already queued up. "And you made it look like you weren't trying to score points. That's rare." "That's because I wasn't," Crockett replied, flipping through the pages without much interest. People often forget the law isn't about winning arguments. It's about uncovering the truth and making sure it holds up even when no one is watching. Louise hesitated before asking, "Do you think he'll change how he reports gifts and travel after this?" She placed the papers on the desk and met Crockett's eyes. "Maybe," Crockett said. "Maybe not. But that's not the point." The point, she explained, was that the American people had just seen that even the highest court in the land isn't above answering for its actions. Tasha leaned against the desk. "Advocacy groups are already asking if you'll push for binding ethics rules for the court. They think you've got the momentum to lead it." Crockett rubbed her temples. "Momentum is fragile. Today, they're cheering. Tomorrow, they'll be on to the next headline, unless we follow through. If we're doing this, we do it like today. Every fact bulletproof, every argument airtight." A knock interrupted her. A man in a gray suit stepped in, late 60s, leather folio in hand. Crockett recognized him instantly. Retired judge Michael Brenner, a respected D.C. Circuit veteran. "That," Brenner said, "was one of the finest uses of precedent I've seen in a political setting." You didn't let him slip away, and you never lost your composure. Reminded me of the days when justices were still sharp enough to be rattled. Crockett rose to shake his hand. That means a lot, Judge, especially from you. He smiled faintly. Don't stop now. Asking the question is the easy part. Making sure the answer turns into action. That's the work. When he left, the room felt quieter. Tasha and Louise went back to their laptops, handling interview requests. But Crockett's mind was elsewhere, already thinking about what today would mean years from now. Would law students see this as an example of accountability in action? Or just another political flashpoint? From her window, the Capitol dome caught the evening light. Outside, Washington moved on. Staffers heading home. Tourists taking photos. Lobbyists rushing to dinners. Inside, she opened her laptop and began drafting a memo. Top subject line: Judicial ethics reform. Immediate steps. First line: Today was proof we can demand answers. Now we have to demand change. For Crockett, the real victory wasn't the viral clip. It was the possibility that someone, somewhere in power, might think twice before accepting something they couldn't explain under oath. Still, before turning to legislation, she had one more message to deliver, this time for the people who had been watching from their living rooms, wondering if accountability was still possible. That evening, long after the hearing faded from breaking news into commentary, Crockett sat in front of a small camera in her D.C. office. No gavel, no committee table, just her, a microphone, and her audience. I want to thank everyone who followed today's hearing, she began. What you saw wasn't about one person versus another. It was about making sure that every public servant, no matter how high their position, answers to the people they serve. Her tone was calm but deliberate. She explained why she had pulled a 30-year-old precedent, not for drama, but to prove that principles only matter if they're applied consistently. Whether in a city council or the Supreme Court, accountability isn't comfortable, she said. It's not supposed to be. Power will always have excuses, but the law doesn't bend to comfort. It bends to truth, and truth must be visible, not hidden in incomplete reports or private meetings. She leaned closer to the camera. If you take anything from today, let it be this: you don't have to raise your voice to stand your ground. You don't have to be in the majority to demand answers. You just have to be ready with facts, with patience, and with the resolve to keep going even when others want you to stop. Across the country, people pause to listen. Parents over dinner, law students on their phones. Crockett credited her staff, reminding viewers that what happened wasn't just her work, but the product of many hands. You might never question a Supreme Court justice, she said, but you will face moments when you have to speak up against something that's wrong. How you handle those moments will define you. She didn't hide the risks. You might lose friends, face backlash, or be made to feel like the problem. But silence only protects the status quo, she added. And the status quo isn't always right. Her closing words were steady. I'm not here to make politics more comfortable. I'm here to make sure it serves you. I'll keep showing up prepared no matter who's in the witness chair. If you believe in holding power accountable, stand with me. Support the work. Tell others why it matters. The more of us there are, the harder it is for the truth to be ignored. Stay informed and keep asking questions. That's how we make change together. When the recording stopped, there was no applause, only the quiet hum of the equipment. Shutting down, outside, the Capitol glowed in the night. Somewhere, Clarence Thomas was likely reviewing the day with his advisors. But the record was set. The questions had been asked. The answers, whether satisfying or not, now belonged to the public. And the clip of her closing message would spread almost as widely as the hearing itself. Not because it was fiery, but because it was steady. And because it reminded people that accountability isn't an event. It's a habit. And for those who doubted whether the system could still hold its most powerful members to account. It was proof, however brief, that the answer could still be yes.